If I could just glance
Yeah.
at it.
Address your remarks to the judge, okay? And don't look at the defendant.
Just 1 minute, let me get my camera changed here. All right, so you're a good bit taller than my camera, but that's fine. Good morning, sir. Could you please begin by stating your name and then telling me how this has impacted you and your family?
I'm Preston Dennison.
What's your last name?
Dennison.
Denison. All right, and your relation to the business?
I'm their grandson.
All right, go ahead, sir.
I want to say thank you to everyone that has been involved in the case. My mom has always said, or has always told me, that God does everything for a reason and has a plan. After the day that my papa died, that I looked up to like a dad, I knew that life would never be the same, that you can't even trust your own family, that you got to watch your back with everyone that's around you, that you can't open up to anyone or they will just hurt you in the long run, until one day you have to realize that life is going to move on around you no matter what. The rest of the world don't care. But what I can tell you is my family has is now stronger than ever. My brothers are the strongest young men I know, and they just lost their dad, and they're still doing great things, and the best they can. My mom is all of our rocks, and she keeps us all together every day, and does it with a smile, even if everything ain't okay. She has helped me come so far as a person. Without her, I don't know where I'd be. My Aunt Angela is the best aunt I could ask for. And she has always been there and helped me whenever, even if it's calling her late night to do math homework that me and my mom didn't know how to answer. She reminds me of my papa. She is following in his footsteps and has found the person that's right for her. Matt is her new fiance, I'm pretty sure, and he treats her as well. And he has treated us well and her well through all of this, and we all love him for that. My papa, he won't be able to ever see her get married or my mom get married or me and my brothers graduate. But in the end, we all push harder because we know he is watching. At the end of the day, we are all family. In the Bible it says, and we stand praying, if you hold anything against anyone, forgive them, so that your Father in heaven forgives you of your sins. With that being said, I forgive. Yes, all of our lives have been changed, and there is hate, and there has been many tears to the point where I can barely even cry anymore. But nothing can be changed. They are gone, and I believe with my whole heart they're in a better place together. So thank you to everyone, and everyone that has spent their time on this the past 2 years. Thank you.
Anything else to say?
No, Your Honor.
All right, Mr. Halstead, any proof or argument for this case?
No proof, Your
All right, this is Mr. Guy with the penalty. Argument, sir. Mr. Halstead.
Yes, Your Honor. We are here, of course, about whether the sentencing on the abuse of corpse charges. Our position is that Mr. Guy has no prior record at all. This is his first charges. And so we think that there's no significant reason, no significant enhancing factors to run those sentences above the minimum. So we would ask for the minimum sentencing due to his lack of a prior record. I can go ahead and address, I guess, the multiple convictions. I think that's obviously the state seeking consecutive punishment, and that is what they've written in their memorandum. Our position is, of course, none of the factors apply except perhaps number 4, which is the one they're relying on, dangerous offender whose behavior indicates little or no regard. Our position is at a minimum that one of the factors you have to look at there is whether consecutive sentencing is necessary under the circumstances. And in this situation, we would argue that due to Mr. Guy's age at the commission of these crimes, he'll be in his late 70s before he's eligible to get out, even with concurrent sentences. So our position is that consecutive sentences are not in fact necessary in this case. Under the circumstances, if he does make it 51 years in prison and gets out when he's, let's see, as I said, in his late 70s, he would no longer be the danger that you might think that the state might argue that he is now. So we would ask this court to run all sentences concurrently.
Thanks, sir. All right. So including the arguments that we've heard today from the parties, as well as the additional victim impact that's been received, I want to begin by citing 4035-102, and the court is required in sentencing decisions to consider the principles of sentencing. The first one, and number 1, says every defendant shall be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense. And I think that principle carries a lot of weight with the court in today's sentencing. Now, there's other principles as well, including it should be consistent with across the board for everyone, so you eliminate unjustified disparities among persons. And also, you want to provide effective deterrence to the community. You consider defendants with lengthy criminal histories more closely, and take steps to encourage rehabilitative efforts when possible. And since it should exclude all considerations such as race, gender, creed, religion, national origin, and in recognition that prisons are full, then crimes against persons are generally considered more substantial and weighed more in favor of confinement. And so, looking at all that, the court first considers the manner in which these sentences should be served. Obviously, the murders are automatic life sentences, and so the only thing the court has to determine concerning the manner of any of these sentences are the abuse of a corpse charges, and those are Class E felonies. The court does find beyond a reasonable doubt that the defendant is in fact a Range 1 standard offender because he has no prior felony history. And so the potential range of punishment on each of those counts is 1 to 2 years in prison at a 30% sentencing rate. The court does find that the defendant does not have a long criminal history. It's a clean criminal history, so that does not justify confinement on those counts. Is it necessary to avoid deprecating the serious offense? I do find that that factor applies in this case and weighs heavily toward confinement. This wasn't just an abuse of corpse where somebody kills somebody during a robbery, goes out and sets their bodies on fire or tries to bury them. This was the most extreme form of abuse of a corpse I've seen in 25 years. Hopefully it will be the most severe that I've seen in my entire career, however long that lasts. And so I do think that that factor alone warrants confinement on the abuse of a corpse counts. The others I don't think really apply, other than does he have potential for rehabilitation or treatment. In this particular case, I don't see any potential rehabilitation in Mr. Guy. I was watching him during the trial. He showed absolutely no remorse or despair at seeing what he had done. Quite frankly, Mr. Guy, you look like you're kind of proud of what you had accomplished. And so I think we could have 500 years to try to rehabilitate Mr. Guy and be unsuccessful. So I think that factor as well weighs toward confinement in those counts as well. Now, as I stated, there's been no argument for enhancement factors, and I don't think any of them would apply. The enhancement factors are merely advisory. The court is not bound to those. It's not like you do some math equation and, well, we got 3 enhancement factors and no mitigation factors, and then you do some type of equation. It doesn't work that way. In this case, just looking at the facts alone, it would warrant a sentence at the top of the range in each of those counts. The mitigation that's been presented really consists of the fact that the defendant has no prior criminal history, which I do find is true in this case. However, I think it's greatly overwhelmed by the evilness of the actions of Mr. Guy in this case. So So I do think a sentence at the top of the range in each of the abuse of corpse is warranted, as well as confinement. So the only other question for the court to determine is whether or not these sentences should run consecutive. They're not mandatory consecutive, and so the court has to look at potential discretionary consecutive sentencing. And the one that's been cited is what we refer to as the dangerous offender factor. And not only does the court have to find that a person is a dangerous offender whose behavior indicates little or no regard for human life, which I do in this case. He had no hesitation about committing a crime which risk of human life is high. In fact, that was his goal in this, was to end human life. You also have to find what we refer to as the Wilkerson factors. And one of those are the circumstances surrounding the commission of the offense aggravated. And so when we look at the murder counts, I do find that they're aggravated. Mr. Guy was stabbed 42 times in his torso, and Miss Guy over 30 times. This was a crime of, I want to say anger, but I'm not sure it was. This was just a crime of just pure evil overkill. And he was sending a message to his parents and perhaps to his family through his actions. And then the steps that he took to try to dispose of their bodies was beyond anything that would be necessary to form abuse of a corpse. And so I certainly find that the circumstances in this case were aggravated. Is confinement for an extended period of time necessary to protect society from the defendant's unwillingness to lead a productive life and the defendant's resort to criminal activity and furtherance of anti-societal lifestyle? And in this case, Mr. Halstead is arguing this factor doesn't apply in that the defendant has no prior criminal history. He is going to be in his 70s, if I ran these concurrent with one another before he got out of jail, and would unlikely be a threat to society. And I'm sure there'll be a lot of physical deterioration in Mr. Guy over the next 51 years. But even then, it's his mind that I'm most worried about. He certainly has evinced a sick and depraved mind. He's certainly not mentally ill. He knew exactly what he was doing. He didn't go about it in a very intelligent way, but in any event, I do think confinement for an extended period of time is necessary to protect society, because I don't think Mr. Guy's mind is going to change at any point. And finally, the aggregate length of the sentence reasonably relates to the offenses for which the defendant stands convicted. And I am aware that if I give him the maximum sentence and stack it, that there'll be 130 years before he'd be eligible for release. Quite frankly, if it was 300 years, I don't think that would still be sufficient to reasonably relate to the offenses for which he is committed. And so I was thinking, is there any closing remarks that I need to make in this thing? And there's not a whole lot for the court to say. The case really speaks for itself. Mr. Guy, I think, thinks he's a lot smarter than he really is. And some of the things he said in this letter that the state has presented, where he's threatening to blind his cellmate so he can get a cell to himself, which not thinking that through any better than he thought through his homicides. And so this is just a pure act of evil, and it was done in a really unintelligent way. And I think that's probably what would bother Mr. Guy the most, is me saying he's unintelligent. So, Mr. Guy, at this time, I ask you to stand up. I'm going to sentence you in this remaining counts. Joel Michael Guy and Dr. number 110145, the court has already pronounced a life sentence in count number 1. The court is going to merge count number 4 into that life sentence. Count number 2, the court has already entered a life sentence for Lisa Guy, and counts 3 and 5 merged into that. I'm going to order that count 2 run consecutive to count number 1. In count number 6, abuse of corpse of Joel Guy, I sent you the maximum sentence of 2 years to run consecutive to count number 2, and in count at a 30% sentencing rate. Count number 7, abuse of corpse of Lisa Guy, will be the maximum sentence of 2 years and 30% consecutive to count number 6. So it's a total sentence of 2 life sentences consecutive with 4 years stacked on top of that. So you can have a seat, Counselor. All right, the next part of the proceedings will be the filing of a motion of new trial. You have an absolute right to appeal in these matters, and the public defender will remain your attorney for that. I do want to set a status date. Mr. Halstead, I know you may not have the final motion for new trial prepared by our next day, but I want to make sure we keep it on the calendar so we don't lose track of it. How about status on February 5th? That's a Friday.
I'm sorry, I was.
February 5th for
That's
status.
fine with
Motion
me.
for new trial.
Yes, Your Honor.
All right, so we'll have a status hearing on February 5th to see how close we are to having the motion for new trial prepared and go forward from there. All right, thank you, folks. Of course, we'll take a recess. We'll come back again in the regular.
Your Honor, one additional thing, he would like to stay here pending the motion for a new trial. I've actually dictated it because I promised him I'd get it done quickly. I've given him part of it. I'm going to give it, the rest of it to him tomorrow.
I don't have control of that, Mr. Halstead. Once I enter the judgments, he belongs to TDOC, and I'm going to enter the judgments today. So I can't tell TDOC they can't come and get him. So they may come and get him, and I have no control over that.
Based on prior discussions, he may end up waiving his right to be brought back. I'll discuss that with him, but we'll do that in writing.
Okay, yeah, I've had the
Okay,
Thanks, sir.
thank you.
Thank you, Your Honor.